We said that the free movement of goods in the European Union is based on a customs union. As we've stated before, customs union has three components. First is the common commercial policy and a common external tariff, which will apply in trade with third countries. Second, prohibition of custom duties and charges having equivalent effect. And third, prohibition of quantitative measures or quantitative restrictions and measures having equivalent effect. The customs duties and charges having equivalent effect are also known as tariff barriers. Or fiscal barriers. Fiscal? Maddi. Fiscal barriers. Quantitative measures and measures having equivalent effect are also called non-tariff barriers. So the first component is an external customs tariff, a common customs tariff for the European Union. We have stated that in the free trade areas especially, there is no such external tariff. When we say external, we understand the trade with third countries. And as a stage of integration, economic integration, we stated that in the free trade areas, there is no such external tariff. So we stated the disadvantage of free trade areas. Do you remember? The third country, since there is no common external tariff, that the third country shall always be in a relationship with the country which has the lower tariff for its goods to be in circulation in the free trade area. And in the customs unions, therefore, one of the components is an external common tariff when trading with third countries. Therefore, when the EU member states are doing trade with third countries, then they will apply the same external tariff, which is fixed by the European Commission. Then when trading with that third country, once this external tariff is paid, since it is a common tariff, it will be the same amount of duty to be paid. Then the good is in free circulation in the EU's internal market. The second important component is the prohibition of customs duties and charges having equivalent effect. This is today provided under Article 28 and 30 of the Treaty on the Functioning of the European Union. The first aspect is therefore, or in more general terms, it is first provided in the Article 28, and it says that the EU is based on a customs union and it shall cover all trade in goods. What does this mean, all trade in goods? There is no such definition in the founding treaty. The Court of Justice has defined this phrase, all trade in goods, in the Commission versus Italy, in case 7/68. Commission versus Italy. The case is also known as art treasures. According to that decision, goods are products which can be valued in money and which are capable as such to form the subject of commercial transactions. Goods are products which can be valued in money and which are capable as such to be subject of commercial transactions. Then in 1987 and in 1990, in two decisions, the first one was case 45/87, Commission versus Ireland, and the second one was case 2/90, Commission versus Belgium. The court ruled that in the first one, the provision of goods within a contract for the provision of services. The provision of goods within a contract for the provision of services is considered as a good in terms of Article 28. And in the second decision, it provided that non-recyclable waste is also involved within the definition of goods. Therefore, as far as this second requirement is concerned, the member states is prohibited from applying customs duties and charges having equivalent effect. Therefore, it also has two different aspects. As far as prohibition of customs duties is concerned, today, in the year 2019, there is not much problem about that, because customs duties can be easily understood from the price of the good. It is a clear duty applied at the border of a member state, and it is obvious. The member states do not attempt to apply customs duties when trading with each other anymore. But one important case about prohibition of customs duties is the Van Genan-Loos case. Case 26/62, Van Genan-Loos, where the Court of Justice interpreted Article 30 of the Treaty on the Functioning of the EU. This used to be Article 12 of the EU-EC Treaty, and the court provided that this provision is directly effective. The main problem as regards this requirement is about charges having equivalent effect. The customs duties are more obvious, but what is a charge having equivalent effect? Any ideas? Yes, Gül?
Maybe internal taxation, additional taxation within a state.
Okay. About this requirement, prohibition of customs duties and charges having equivalent effect, we understand, especially for customs duties, they are applied at the border. When we say internal taxation, I will say in a minute. It is not included here. Okay? When we speak about internal taxation, as you will be seeing, this is provided under Article 110 of the Treaty on the Functioning of the EU. It is not involved in this prohibition, because as you will be seeing, when the good is already within the territory of a member state, the member state may apply tax on that good if it also applies that tax on its national products, okay? So internal taxation is something else. Unfortunately, the Turkish translation is misleading, okay? This is vergi, we translate this as vergi as well, but this is the one that is applied at the border, not in that member state, all right? So it is not that. What is a charge having equivalent effect to customs duties? Yes, Deniz?
For example, the member state exports the goods and it sells the goods with the same price to any member state. It may be. Because I read the case and a little bit. It's about importation and exportation.
Exactly. Yeah. This is always about import and export, since it's about trade between the member states. But what is a charge having equivalent effect? That must be something fiscal, right? Okay. There is no definition of a charge having equivalent effect in the founding treaties. One of the most important decisions of the Court of Justice is the statistical levy case of 1969, where the Court of Justice provided for a definition of a charge having equivalent effect. According to the court, any pecuniary charge, however small, and whatever its designation, and mode of application, which is imposed unilaterally on domestic or foreign goods because of the fact that they cross a frontier, because of the reason that they cross a frontier. Therefore, is the amount of charge important? It is not important. The amount of the charge is not important. It will be very small. The mode of application is not important. It may be applied on the foreign products, imported products, or on the domestic products. They apply just because the goods cross a frontier. Frontier? Sınır. Therefore, the charges having equivalent effect, or a charge is considered as a charge having equivalent effect, even if it is not imposed for the benefit of the member state concerned. It may not be imposed for the benefit of a member state, as you will be seeing. It can still be considered as a charge having equivalent effect, even if it is not discriminatory, it does not discriminate, and even if the product is not in competition with any domestic product. For example, in the cases 2 and 3/69, a levy was imposed on diamonds. And the levy that is imposed on diamond imports was going towards a social fund, not to the member state, but to a social fund for the workers in diamond industry. The levy obtained from the diamond imports was going to a social fund for workers in the diamond industry. And it was not used in any protectionist way to protect the domestic products. It was about Belgium, and Belgium was not producing diamonds. However, the Court of Justice provided that such a payment is also a charge having equivalent effect, because the imported goods became less competitive. In the founding treaty, there is no defense for a breach of Article 30. Because as you will be seeing, there are certain defenses, especially for the prohibition of quantitative restrictions. But here, no. There is a clear prohibition, and the customs duties and charges having equivalent effect between the member states are prohibited. But there is no clear defense in the founding treaties against this prohibition. But the Court of Justice provided for certain situations as outside the scope of Article 30. Therefore, the situations that I will be mentioning in a minute are situations as decided by the court as outside of Article 30, these are not exceptions of Article 30, on the contrary. These are not exceptional situations, but these are not just considered within the prohibition as provided under Article 30. The first situation is where the payments are made for the genuine administration services rendered or given to the importer or exporter. According to the court, when the payment is made for a genuine service of direct benefit for the individual importer or exporter, then it is not a charge having equivalent effect. Therefore, it will be lawful if the payment is made for a genuine service given to the importer or exporter. However, the court, I would say, apply this in very strict terms. For example, in the case of 1987, 34/87, in Commission versus Italy, the Italian authorities charged traders for opening customs posts beyond the normal working hours. The Italian authorities charged certain payments because the customs posts were open beyond the normal working hours. And they claimed that these payments charged are not considered as a charge having equivalent effect because this service was provided for the traders and for their direct benefit. The Court of Justice said that there is a community directive providing for the customs posts to be open at that hours anyways. According to the court, therefore, there was an EC directive that provides for those hours as working hours. Therefore, this was a charge having equivalent effect for the court. Secondly, second situation which would not fall under Article 30 is the charges for inspections required by European Union law. According to the court, if costs are required, certain costs are required to comply with inspections or mandatory inspections required by EU law, then this shall not also be considered as a charge having equivalent effect. But for this situation to apply, there are 4 conditions to be satisfied. First is that these costs should not exceed the actual costs required for the said inspections Second, the inspections must be obligatory and uniform. In the EU. Third, they are prescribed by the European Union. They must be prescribed by the European Union in the general interest of the EU. And lastly, they promote to the free movement of goods. For example, in one decision, the German government was found entitled by the Court of Justice to charge a fee for the inspection of veterinary services under an EC directive. Therefore, that charge was not called as a charge having equivalent effect. What is the most important part about prohibition of customs duties and charges having equivalent effect, and where the most case law today is about internal taxation? Attention, internal taxation, or the third situation where Article 30 does not apply here is charges falling within the scope of internal taxation. Most of the case law is about this situation, and it is not about Article 28 and 29. Okay, this is the third situation, which is provided by the Court of Justice as outside the scope of this prohibition. Okay, and it is subject to Article 110 of the Treaty on the Functioning of the EU. For the coming hours, I will ask you to bring the founding treaties, okay? At least, please have these provisions we mentioned with you, so it will be much easier for you. If a charge relates to a general system of internal taxation, if a charge relates to a general system of internal taxation, applied systematically, and in accordance with the same criteria, to domestic and imported products, then the charge does not fall within Article 30. As we mentioned, Article 30 addresses fiscal barriers to trade applied at the frontier. Article 110 applies internally within a member state. Therefore, Article 110 deals with fiscal barriers, fiscal rules, which apply internally within a member state. If a financial charge is a part of general system of taxation of a member state, if it is a part of general system of taxation of a member state, and if it's applied systematically to domestic and foreign products, imported products, and according to the same criteria, it is not considered as a charge having equivalent effect. Attention, if a payment is asked by a member state, it may either be a charge having equivalent effect or a tax under this provision. It cannot be both. It is either one or the other, all right? Do not get confused. Then we move to Article 110, which is related also with the free movement of goods, although it is something else. Then prohibition of customs duties and charges having equivalent effect. In all the chapters I have given you, you would find certain explanations, detailed explanations as regards Article 110, because as I said, most of the case law is about this part of the subject. Article 110 prohibits discriminatory taxation. Under the first paragraph of Article 110, it is provided that no member state shall impose directly or indirectly on the products of other member states any internal taxation of any kind in excess of that imposed directly or indirectly on similar domestic products. No member state shall impose directly or indirectly on the products of other member states any internal taxation of any kind in excess of that imposed directly or indirectly on similar domestic products. Does this provision prohibit internal taxation?
If it is different than the domestic products, yes.
Yes. As a principle, it does not. What it prohibits is that if taxation or if tax applied on imported foreign products is different than the domestic products, yes, it is prohibited. This can be directly or indirectly be different than the one applied on domestic products. And here, in the first paragraph, what is important is that it prohibits direct and indirect discrimination in taxation, first very important component, it prohibits direct and indirect discrimination on internal taxation. Second, on which goods it does this? Foreign or domestic, between the foreign and domestic goods, but what type? On similar. That is important. Please make sure that you know these two important aspects, that indirect and direct discrimination on taxation of domestic and imported products are prohibited. Second, what is important is that the products are similar. We will come back to this provision in a minute. The second paragraph reads as follows. Furthermore, no member state shall impose on the products of other member states any internal taxation of such a nature as to afford indirect protection to other products. Therefore, in the first paragraph, similar products are provided, and the second paragraph provides rule for other products. In other words, in the first paragraph, the treaty prohibits the host member state from applying higher tax on goods imported than on similar domestic products. Then the question arises, what is similar? What do you say? What is similar? Same? Is it included? When I say similar, do I also include same? Yeah. Yes, of course. Of course, obviously, similar, the term similar first includes same product. And the Court of Justice takes different characteristic of a good to decide if it is, or the goods, if they are similar. First, composition. You will be seeing in the examples I will be giving in a minute. Second, physical characteristics. Third, the method of production of the product, as well as whether the two products satisfy the same needs of the consumer, or whether they are in competition with each other and thus substitutable, meaning whether they substitute each other. There are interesting cases. You will find many more in the book. I would just give the most important ones. One of them is the John Walker case of 243/84, the John Walker case before the Court of Justice. The question was whether whiskey was similar to a fruit wine. While it was clear that both were the alcoholic drinks, the Court of Justice provided that they were not similar because they had certainly different characteristics. The wine was fruit-based, and it relied on natural fragmentation, whereas Scotch whisky was cereal-based and it was produced by distillation. they also had significantly different alcohol amounts in themselves. Another example was from 1985. Commission versus Italy. Or in some books you would find references to the Italian fruit case. When I say Commission versus Italy, what kind of action this could be? An action for infringement. Here the court considered whether the bananas on the one hand and the peaches and peas on the other were similar products. And it considered that they were not similar. The court referred to different characteristics of these goods, including the amount of water, and they were suited to different markets. The third example is from 84. Commission versus Denmark. Where the court considered whether wine made from grapes and wine from other fruits were similar products. It provided that they had similar alcohol content. They were produced in the same way, and they were substitutable. Therefore, they were similar products under Article 110. If the products are not similar, therefore do not fall, or the payment does not fall under the first paragraph of Article 110, because it requires existence of similar products, then the question arises whether this situation falls under Article 110, paragraph 2, meaning for other products, the requirement for other products. Okay, let's stop here and we continue on Friday. Yes.